Welcome to this electronic training, Section 504 Legal Issues. This is an administrative training brought to you by the Department of Legal Services. My name is Jeff Christensen, and I am the Assistant Legal Counsel for Canyon School District. During this presentation, we will review Section 504 of the Rehabilitation Act of 1973 in the context of other federal laws in order to gain a better understanding of Section 504. To begin, we will review Title II of the Americans with Disabilities Act, and then later we will compare Section 504 with the Individuals with Disabilities Education Act, or the IDEA. The Americans with Disabilities Act, or the ADA, is a federal law which protects the civil rights of all individuals with impairments in society, similar to those provided to individuals on the basis of race, color, sex, national origin, age, and religion. The ADA guarantees equal protection for individuals with disabilities in public accommodations, employment, transportation, state and local governments, and telecommunications. I am certain that those listening to this presentation can think of an example of an ADA accommodation in public employment, transportation, or state and local governments. Section 504 of the Rehabilitation Act of 1973. Section 504 is more encompassing than the Americans with Disabilities Act. Section 504 could cover students, parents, employees, and other individuals with impairment. The Section 504 definition of an impairment is much broader than the ADA. It includes any physical or mental disability that substantially limits one or more major life activities, including, but not limited to, learning. For public schools, Section 504 covers all students who meet this definition, even if they are not eligible under the Individuals with Disabilities Act, or the IDEA. The IDEA, or the Individuals with Disabilities Education Act. This law defines eligible students as those who have certain specific types of disabilities and who, because of those conditions, need special education or specially designed instruction and related services in order to benefit from their education provided through an individual education program. In this case, the IDEA is more specific than Section 504, pertaining to specific and specially designed instruction. What is the ADA Amendments Act? The Amendments Act was signed into law in September 2008 and became effective on January 1, 2009. Congress passed the Amendments Act in part to supersede Supreme Court decisions that had too narrowly interpreted the ADA's definition of a disability. As members of Congress explained, the ADA Amendments Act rejects the high burden required by the Supreme Court and reiterates that Congress intends that the scope of the Americans with Disabilities Act be broad and inclusive. The ADA Amendments Act. The ADA Amendments Act does not alter the school district's substantive obligations under Section 504. Rather, it amends the ADA in Section 504 to broaden the potential class of persons with disabilities protected by the statutes. Now let's turn specifically to what we mean by what is a physical or mental impairment that substantially limits a major life activity. In the regulations, the Section 504 regulatory provision defines a physical or mental impairment as any physiological disorder or condition, cosmetic disfigurement, or anatomical loss affecting one or more of the following body systems: neurological, musculoskeletal, special sense organs, respiratory, including speech organs, cardiovascular, reproductive, digestive, genitourinary, hemic and lymphatic, skin, and endocrine, or any mental or physiological disorder such as mental retardation, organic brain syndrome, emotional or mental illness, and specific learning disabilities. The regulatory provisions does not set forth an exhaustive list of specific diseases and conditions that may constitute physical or mental impairments because of the difficulty of ensuring the comprehensiveness of such a list. We now turn to look at major life activities. Major life activities, as defined in the Section 504 regulations, include functions such as caring for oneself, performing manual tasks, walking, seeing, hearing, speaking, breathing, learning, and working. In the Amendments Act, Congress provided additional examples of general activities that are major life activities, including eating, sleeping, standing, lifting, bending, reading, concentrating, thinking, and communicating. Congress also provided a non-exhaustive list of examples of major bodily functions that are major life activities, such as the functions of the immune system, normal cell growth, digestive, bowel, bladder, neurological, brain, respiratory, circulatory, endocrine, and reproductive functions. Now that we have reviewed the physical impairments and mental impairments, as well as major life activity definitions under the regulations of Section 504, we will now turn our attention to some comparing and contrasting slides between Section 504 and the IDEA. As you will see listed in these slides, there are Section 504 is listed on the left and IDEA is listed on the right, and then you have specific bullet points for the comparing and contrasting between each of these. As you look at these slides, you will see that there are some specific differences. Section 504 applies to general education. It's a civil rights law. There is no separate funding mechanism. There are no categories to qualify for Section 504, and a student is served under a 504 plan. Under the IDEA, that's a special education law. It applies to special education. It's an education funding law. There is federal and state funding, and there are disability categories, and students are served under an IEP. In this slide, we look at additional differences between Section 504 and IDEA. The first issue we will look at is the legal standard. Under Section 504, the standard is equal opportunity, or not focused on results. In this case, schools meet the educational needs of disabled students as adequately as the needs of non-disabled persons. Under the IDEA, the U.S. Supreme Court Rowley standard is applicable. In this case, schools must provide an educational program reasonably calculated to provide educational benefit. In this slide, we review a few additional differences between Section 504 and the IDEA. Specifically, we look at committees/teams that are charged with making a decision regarding Section 504 eligibility, or the IEP team, which is charged with reviewing and making adjustments to the individual education plan. Under Section 504, the committee or team is not as prescriptive. The team must be knowledgeable about the child, evaluation data, and placement options, but there is some flexibility in the team. In contrast, under the IDEA, the team is defined specifically in the implementing regulations. As a result, Section 504 is less specific, but does recognize procedural safeguards from initial evaluation to an impartial hearing with right to counsel. And again, the IDEA provides extensive procedural safeguards. We now turn our attention to Section 504, General Requirements. Section 504 ensures that disabled students have educational opportunities and benefits equal to those provided to non-disabled students. Schools must provide equal opportunities, same results, same benefits, and levels of achievement. We now turn our attention to the main legal issues under Section 504. The first of these is child find. In this case, if the district/school has reason to believe or suspects that a child may qualify for Section 504 accommodations, they need to evaluate said child. A request from parents/legal guardians for 504 accommodations does not need to be in writing. Another significant issue is Section 504 plans versus health plans. Even if you think a child just needs a health plan to meet their needs, a Section 504 evaluation should be done. If they qualify for Section 504 and health plan, complete them separately. The Office of Civil Rights determined that a district's practice of providing health care plans to students with diabetes instead of determining their eligibility for a 504 plan was a violation of Section 504 child find requirements. Districts must evaluate a student's eligibility for a Section 504 and related aids and services, rather than automatically writing a health care plan. CSD Section 504 implementation. Section 504 eligibility determination. Anyone can request a review for eligibility: school, staff, parent, or legal guardian. This is done through a Section 504 referral. Once a referral is received, the school coordinator will send public notice of Section 504 procedural safeguards to parents and legal guardians, send CSD parent notice and consent for evaluation, and assemble the Section 504 team and gather information. This slide really deals with that once we have a request for eligibility, then it triggers the district's obligation through the Section 504 coordinator to engage in some steps to provide notice to parents and get consent and gather the team and gather information and do the evaluation. Procedures and rights of parents/legal guardians. Procedural safeguards and protections include, but are not limited to, the right to notice for identification, evaluation, program, or placement of your child. An opportunity for parents/legal guardians to examine their student records. Have the school advise you of the rights under the federal law. Have your child receive a free, appropriate public education. Participate in the initial evaluation and placement for services and accommodations for your child. Have your child education in facilities and receive services comparable to those provided to students without disabilities. The above procedures and rights of parents and legal guardians, the procedural safeguards, are included in our district policy, and this is the information that's provided in written form to parents and are the related safeguards for Section 504. The Section 504 team. Once again, this is a review of the Section 504 team. The team must include individuals knowledgeable about the needs of the student, the meaning of the evaluation data being reviewed. The team may include, but is not limited to, school principal, classroom teacher, school nurse, counselor, school psychologist, and parent/legal guardian. Evaluation. Eligibility meetings scheduled and invitations sent to parent/legal guardian. Notification to the parent is required before an eligibility determination can take place. Eligibility meeting held and determination made. Decisions made by anyone other than the appropriate Section 504 committee are in violation of the 504 regulations. Section 504 Accommodation Plan. If the school Section 504 team determines the student is eligible, the team must determine if accommodations are necessary to allow the student equal access to and benefit from the educational opportunities and services. If so, The school Section 504 team develops a 504 plan that outlines the appropriate student accommodations. If not, no Section 504 plan is necessary. The school will provide a copy of the district's grievance procedures. Grievance procedures. If any person believes that the school or any of its staff have not followed the regulations of Section 504 of the Rehabilitation Act, he/she may initiate a grievance with the district's Section 504 coordinator. Upon request, the district's 504 coordinator will provide a copy of the district's grievance procedures and investigate all complaints in accordance with Section 504 of the Rehabilitation Act and Title II of the Americans with Disabilities Act. As part of this presentation, we have provided the grievance procedures, which are also located in our district policy. In this case, it's a two-step grievance process. Step one refers to the district investigation, and in the district investigation, the district's 504 coordinator will review the grievance and meet with the parent or legal guardian to hear their concerns. The Section 504 or District 504 coordinator will decide whether to mediate the dispute between the school and the parent or legal guardian, or in other words, simply provide a decision in writing. Once a decision has been made, that will be provided to the parent or legal guardian within 10 business days of receiving the grievance. At that point, again, our school board encourages students and parents and guardians to seek informal resolution of their concerns, and that is why the district provides as part of its policy a mediation process. If the concerns are resolved, the formal grievance can be withdrawn at any time. Step 2 refers to a due process hearing. If the Section 504 coordinator's mediation effort or written response fails to resolve a parent/legal guardian concern, a parent or legal guardian may request for an impartial due process hearing. A request for a district hearing must be filed with the district's 504 coordinator within 10 business days of receiving a response from the coordinator date of the mediation. And in this case, the district's 504 coordinator shall schedule a hearing before the district's 504 hearing panel or a non-district hearing officer. So there were two options for this appeal of the decision. They can either go to a District 504 panel or a non-district hearing officer. At the hearing, parents and legal guardian may be represented by legal counsel. And lastly, the parent / legal guardian district 504 coordinator may make statements and present evidence relative to the issues. Just a few. Grievance procedures continued. Just a few more points regarding this section. Again, the hearing panel shall be provided a copy of the grievance and the school's 504 coordinator's written response. And then ultimately, the decision of the district's 504 hearing panel or hearing officer constitutes the final administrative decision on the Section 504 matter. The determination of the district's 504 hearing panel or hearing officer shall be communicated to the parent or legal guardian within 10 business days. Once again, for questions or concerns, please contact Legal Services 801-826-5061. Thank you, and have a great day.